Do defendants and plaintiffs have an obligation to share information about other parties that may be involved in a case? The court in Chalik v. Cooper Hospital et al. Looked to the Federal Rules of Civil Procedure, or FRCP, to answer this question. In 1997, Michael Chalik was admitted to Cooper Hospital after he was injured in a parachuting accident. Michael died the next day at the hospital. In 1999, Michael's father, Conrad Chalik, filed a medical malpractice suit against Cooper Hospital, 4 named doctors, and numerous unnamed doctors and nurses, referred to as John and Jane Does, who contributed to Michael's care. Conrad claimed that all the parties were responsible for Michael's death. In June of 1999, the hospital and the named doctor defendants served Conrad with their FRCP 26A disclosures. The parties' disclosures identified Dr. Richard Burns as a person with relevant knowledge. However, none of the parties' disclosures provided Dr. Burns' contact information. The disclosures also didn't explain what knowledge Dr. Burns had about the case. In December of 1999, during one of the named doctor's depositions, the doctor explained that Dr. Burns was a trauma surgeon who checked on Michael and reviewed Michael's x-rays. Conrad discovered he had a claim against Dr. Burns and filed a motion to amend his complaint to replace a John Doe defendant with Dr. Burns as a named defendant. The hospital defendants filed a brief, arguing that Dr. Burns couldn't be joined as a defendant. The hospital defendants claimed that the statute of limitations for Conrad's claims against Dr. Burns had passed, and that Dr. Burns didn't receive actual or constructive notice of Conrad's lawsuit.